Okay, all right. Well, good morning, everybody. Thank you for joining us for our webinar, 5 frequently asked questions about trusts. My name is Darren Richardson. I'm one of the attorneys here at Eastman Estate Planning. It is my pleasure to be with you this morning. And thank you for taking time out of your day for this webinar to learn a little bit more about some of the questions that come through our office on a regular basis about trust. Maybe these are questions that you have for yourself, or maybe these aren't. It's always just a good refresher in the event that you do have a trust and you have certain questions. We thought that this would be a great webinar to be able to present to you today. So thank you very much for joining us. So just so that you know a little bit about me, I've been an attorney for over 10 years. I've been practicing estate planning exclusively, and I grew up on a farm in Harriman, Utah. I am an Arizona transplant. My wife and I moved here from San Antonio, Texas, which is where she is originally from. And I've been happily married now for almost 19 years and am a father of 3 wonderful children. Now, you probably can't see it on this video, but I've got a scar on the side of my face right here. And that scar comes from melanoma skin cancer that I had when I was just 23 years old. My wife and I were just recently married. I went in for a routine physical and I had a mole on my cheek that I asked the doctor to take a look at. And he said that it looked absolutely normal, shouldn't have any concerns, but I asked him to take it off anyway. And it turns out that it was melanoma skin cancer. So my wife and I received a wonderful phone call about 2 days later at about 6 o'clock in the morning from the doctor himself, letting us know that the biopsy came back as skin cancer, melanoma, and that I needed to head into surgery. I was going to be missing work for a number of days, etc. So as you can imagine, that came as quite a shock to this newly married young couple, and made us really think about our priorities a bit. So thankfully, that was about 20 years ago, and I've been cancer-free since then. But it just goes to show that at any time, life can throw us a curveball that we're just not expecting. And it's always good to be prepared and planned for anything that could come our way. I love the outdoors and traveling. As you can see from these slides, that's me on a whitewater rafting trip in Wyoming on the Snake River. And I'm looking at going on a great white shark cage dive at the end of October of 2023. That's one of my bucket list items. So I'm really looking forward to that. Okay, so just a little bit about Eastman Estate Planning. David Eastman and I are the attorneys here at the firm, and we practice estate planning exclusively. We take a look at estate planning, special needs planning, probate and trust administration. And together we have a combined over 25 years experience. So just a couple of things for you to be aware of about the firm. We are not a litigation law firm. We do not handle any disputed matters. So if you or a loved one or anybody comes to our firm looking to find an attorney to represent them in court because they've got a beneficiary or a trustee or someone trying to sue them or accuse them of a breach of a duty, we do not handle those types of items within our firm. We strictly only practice the planning and the non-dispute administration of an estate. Okay. So just so that you are aware and get familiar with our firm, our mission statement here at Eastman Estate Planning is to motivate and inspire individuals and families to proactively protect their legacies and to give them peace of mind through educating, counseling, and providing premier estate planning solutions. Our legacy preservation planning helps our clients plant seeds today that will leave a perpetual legacy for generations to come. That mission is very important to us, as we hope it's important to all of our clients. Our job as attorneys is to help inform you and to educate you regarding your estate planning needs, as well as the options available to you so that you can make informed decisions based on your circumstances, your goals, your wishes. So that is the aim of the firm and something that we take very, very seriously. Okay, so for today's topic, We're going to discuss 5 frequently asked questions about trusts. Now, before I get into that, I just want to let anybody who is attending know that if you do have any questions for us, feel free to provide your questions in the chat box that's at the bottom of the screen. You can type in your questions there. Or if you don't want to do that, we can simply take questions after this webinar is over. I will provide you with my email address, and you can always feel free to shoot that email a question to me. Also, at the end of the presentation, we will be having a drawing. I've got this cup here with the names of our attendees who will be eligible to win a wonderful prize from our firm as a thank you for joining us for today's webinar. And we'll do that at the conclusion of the meeting, okay? All right, so question number 1. Oftentimes people come into our office and they say, once I've created my trust, what do I need to do next? Now, one of the myths that is out there about trust is that once you sign the document, then you're done. There's nothing else that you need to do. You can take your trust portfolio home, put it on your bookshelf, and then everything is ready to go. That is not true. That is a myth. When you have a trust, when you've created a trust, there is a very important next step in that process. And that next step is called funding. Funding is a legal term that describes the process to retitle your assets into the name of your trust. So if you think about a trust as creating a shell or a box, once you sign that document, you're creating a box. That box does absolutely nothing for you unless it's holding something. And in the case of a trust, in order for a trust to do its job, it needs to hold assets. And those assets get held by the trust by either retitling the assets into the name of the trust or naming the trust as a beneficiary on a beneficiary designation. One of the biggest issues that we see as estate planning attorneys when a loved one has passed away is that they've spent a lot of time and a lot of money to prepare a trust to make sure that their wishes get carried out after they've passed away, only to find out that that trust was never funded. And oftentimes we hear that either they forgot to do it, or even worse, our clients tell us that a previous attorney never told them that they had to take that next step. So that's a very, very important question that we get asked all of the time. What do I need to do next? It's not like a will. When you have a last will and testament and you sign that document, there's nothing that needs to be done until after you've passed away and a probate gets opened, and then the will gets reviewed, and then that process begins. With a trust, once it's signed, you have to take that next step and fund the trust in order for the trust to govern your wishes and make sure that everything gets carried out. One important matter as well is once you create a trust, you want to make sure that you are constantly staying ahead of it, meaning we always recommend that you have your trust reviewed every 2 to 3 years to make sure that your wishes are current, that the trust is current with any law changes that are made within the state of Arizona or on the federal level, to make sure that the trust is going to function properly for you when it needs to be done. Okay, so that's number 1. Question number 2. Does my trust need to be filed with the court or with the state? Again, this is another myth that sometimes we see come through. A lot of times folks think a trust is like a will. A will, when you die, has to go through a process called probate. The probate process is a court-directed process to ensure that your will is properly drafted, that it's a valid will under state law, and then a personal representative is formally appointed to execute your will according to your wishes. A trust is different. A trust is a private document. So there is no requirement to record your trust with the court. There is no requirement to record it with the state in which you live. So once you meet with your estate planning attorney, you execute your document, you take home the original documents, and you simply keep them in a safe place for safekeeping. Some people will put it on a bookshelf. Some people will put it in a safe deposit box. Others will put it within a safe inside their own home to make sure that those originals are protected. Our office will always keep a digital copy on record in the event your original document gets lost, damaged, or destroyed. We've got a digital record on file. So again, question number 2 that we often see is, do I need to file my trust with the court or with the state? The answer to that question is no. Now, that is for the state of Arizona. Estate planning law is governed by state law, which means if you live in another state, that state may have different laws. They may have different requirements when it comes to your revocable living trust. So if you are not a resident of Arizona and you've got an estate plan that was set up outside of the state of Arizona, then you would want to check your local state laws to see if they have some kind of requirement to make sure that that trust gets recorded. But most of the time, most cases, you're not going to see that kind of requirement. You certainly don't see it in the state of Arizona. All right, so that's number 2. Number 3, does my trust provide me with asset protection? So this question does come up quite often. And again, it kind of comes up in the context of a lot of people come into the office saying, I need a trust because I want my assets protected. And I ask, what do you want it protected from? And they say, I want to get protection from lawsuits, from creditors. If I get a divorce, etc., I want to set up a revocable living trust. So again, another myth is that a revocable living trust will provide me with asset protection. A regular, standard, revocable living trust will not provide me with asset protection. There are other types of trusts that are out there that do offer various levels of asset protections. We're not going to get into what type of trust those are in this webinar, but there are other types of trusts. There are other types of estate planning tools that can offer some asset protections for you during your lifetime. But typically, those are reserved for more complex, more complicated type matters. Now, what type of asset protection does a revocable living trust provide? Well, a revocable living trust can provide some asset protection for your beneficiaries after you've passed away. How does it do that? Well, there are 2 types of ways you can make distributions to trust beneficiaries. You can make those distributions by doing what's called either an outright distribution, or you can do what's called an in-trust distribution, okay? The difference is with an outright distribution, your beneficiary is simply receiving their inheritance in their name, and they are free to do what they want with it. They can spend it, they can deposit that money in a joint bank account with a spouse, they can invest it, and everything is in their name. With an in-trust distribution, that inheritance goes to the beneficiary through what's called, what we like to call, a beneficiary trust. This type of trust, the type of trust that we create, is an asset protection trust for that inheritance for the beneficiary. And if crafted properly, it can provide protection against potential future divorce, against potential lawsuits, as well as creditors or bankruptcy. But it has to be properly drafted in order to ensure that those protections are in place, and the assets of that trust have to be very carefully managed to make sure that the protections are in place. So if you have had a discussion with a neighbor or a friend or family member or an attorney that said, I set up a revocable living trust, now all of my assets are protected during my lifetime, you need to give them our phone number and our contact information so we can sit down with them and explain to them how the trust works and identify what is considered a myth and what is considered a reality when it comes to their estate planning. So just to recap that, does my trust provide me with asset protection? A regular revocable living trust does not provide asset protection for me during my lifetime, but it can provide asset protection for my beneficiaries if it's properly drafted. Okay. All right. So number 4 on our list of frequently asked questions is, Darren, do I need to update my trust anytime I buy or sell assets? The answer to that question is no. So when we go back to this funding process and that important step of setting up a trust, sometimes people have the idea and the mindset of, okay, once my trust is created, and once I have changed my bank accounts, my investments, my life insurance, retitled my real estate into the name of the trust, I need to contact my estate planning attorney if I get new assets or if I liquidate assets to make sure that my trust is updated. That is not necessary to do. So when your trust is created, the trust itself does not have specific language regarding your current assets drafted in the document. What we will do is we will provide what's called a schedule of assets that does list the assets that you currently have, as long as we've received that as asset information from you. And then we advise our clients that as you acquire new assets, or when you close assets out or you sell real property, to update that Schedule A to keep a running tally of your current assets. But it does not require you to contact our office. It does not require you to come into the office to let us know that you have acquired a new asset or you have liquidated an asset. And it does not require you to update your trust to reflect that an asset has been sold or acquired. The only time that you might need to update your trust if you got rid of an asset or acquired an asset is if you had a desire to leave that specific asset to a specific beneficiary, then we would need to make sure that that language is very specific within the trust. Or if you had that language in the trust and you got rid of all of those assets, then we might want to review the trust to determine if it's worth removing that language from your trust, or if it's okay just to leave that language in there. Otherwise, we don't need to be notified anytime an asset is acquired or sold. Okay. All right. Now, lastly, number 5, what happens to my trust after I die? Okay. There's a lot of stuff that needs to happen when an individual passes away. One of the main reasons why a person establishes a revocable living trust is because they want to avoid a process called probate. We talked about probate a little bit earlier on, but just as a refresher, probate is a court-guided process to make sure an individual's estate gets administered properly. A lot of people want to avoid probate because it requires petitioning the court and working on the court's calendar, meeting the court's deadlines, and in many cases does require hiring an attorney to assist and be guided through that process. Depending on the type of estate that you have, depending on the beneficiaries and the type of assets, probate can be a very long, difficult, and expensive process, but it could also be a simple process depending on the circumstances. So if you die without a trust, you have to go through that probate process in order for your assets to be administered. Well, if you do have a trust, an administration also needs to occur. Again, the trust does not need to be filed with the court. It does not need to be filed with the state. It is a private document. So after you've passed away, your successor trustee named in your trust document is then responsible to make sure that your wishes get carried out according to the terms of the trust. So they're responsible to make sure they've gathered all of your assets. They've identified how those assets are titled, what the value of those assets are, and then they go through your trust to identify what expenses need to be paid, what taxes need to be filed on your behalf, and then what beneficiaries and how those beneficiaries are to receive their share of your trust estate. So when you pass away, your trust continues to exist. It does not terminate at your death. It continues to exist. The trust will not terminate unless there's some specific language within the trust that says it does terminate at a specific time after you've passed away. Okay. Another time it might terminate is if the trustee has decided that the size of the estate is so small that the trust is no longer required. And there's provisions within the trust that say that a trustee can terminate a trust to administer the estate because this estate size isn't big enough for the trust anymore. So what happens is after you pass away, a trust administration occurs. Once that trust administration has happened, then look at your trust kind of like an empty shell again. When it was first created, it was an empty shell, and we had to fund the trust with your assets. After you pass away, we are now taking those assets out of the trust, unfunding it or defunding it, and now we're creating that empty shell again. And then that trust no longer holds any assets. That trust no longer has any authority over anyone or anything because it no longer holds any assets, and it is simply left as an empty shell. When that trust becomes that empty shell, it could be terminated at that point if the trust provides the ability to do that. Otherwise, that document then just goes away and there's no other action to take on behalf of that trust estate. Okay, so trust administration is a very important process. So as you have your trust and as you've named successor trustees, it's important to make sure that you've got successor trustees nominated that you trust, who have the time and the ability to make sure that your trust is getting managed, that your assets are being managed properly, that they get distributed to your beneficiaries appropriately, to make sure that that trust administration occurs. Sometimes we have situations where a person has passed away and the trust never gets administered. Everything just stays within the trust. And by the time we get notified that a loved one has passed away, then the successor trustee has made a big mess of a lot of things. And then we have to be hired to help unwind everything that's happened to make sure that the trust gets appropriately administered. So if you're a client of the firm, one of the things we recommend, and one of the values of being a client of Eastman Estate Planning, is that we provide your successor trustees with a complimentary estate administration consultation. So they can come in, take an hour or two of our time where we can review the trust document with them, identify all of the provisions of the trust, all of the steps, all of the responsibilities that need to be taken, so that they are armed with the tools and resources necessary to properly get the trust administered. And then if they need our assistance, then they could always reach out to us. We're happy to answer any questions. And if they would like us to get more heavily involved, our firm is more than happy to assist with that administration for a fee. Okay. So just as a recap, what are these 5 questions that we typically see? Well, again, number 1, once I create my trust, what do I need to do next? You need to fund your trust to make sure that the trust is operative and will carry out your wishes. Number 2, does my trust need to be filed with the court or the state? The answer is no, it does not. Okay, that is a private document that you need to have for safekeeping and keeping a safe and secure place. Number 3, does my trust provide me with asset protection? A normal revocable living trust does not provide asset protection, but asset protection can be provided to trust beneficiaries within that trust if it's properly drafted. Number 4, do I need to update my trust when I buy or sell an asset? You do not, unless there's some specific language in your document that could be impacted by the selling of that asset. Then we would at least want to review it to determine if a revision needs to be made. And then lastly, what happens to my trust after I die? That trust needs to go through a trust administration to make sure all of your assets and all of your wishes gets carried out. And then once that administration occurs, either that trust remains as an empty shell or can be terminated at that time, and everything is then closed out after you've passed away. So those are the 5 questions that we often see. We do see a number of questions come through our door on a regular basis, but these are some of the ones that we typically see, and we felt that sharing this in a webinar would be helpful and beneficial for anybody in attendance in the event you had these or similar questions. So with that, we're going to check to see if anybody has any questions. Elisa, did any questions come through for us? Okay, so we do have a question. What type of account should not be in the trust, but should be as a beneficiary to the trust? So that's a very good question. So when you establish a trust, we don't want every asset to be titled in the name of the trust, because there can be some negative consequences from a tax perspective in doing that. The one that comes to mind most frequently is a retirement asset. So if you have an IRA, a 401k, or a 403b, or any other type of retirement asset like an annuity, then those assets, we recommend and advise that instead of retitling those assets in the name of the trust, that we update the beneficiary designations to make sure that the trust is either the primary beneficiary or the contingent beneficiary, depending on whether you're married or whether or not you're single. We want to make sure that it gets updated properly to avoid tax consequences, because there could be some considerable changes and taxes that can be paid if it's done improperly. So my best advice to anyone, if they do question how an asset should be titled or how a beneficiary designation should be updated, is to simply give our office a call. We're happy to help you. We're happy to give you guidance as to how to get the assets properly updated so that the trust is working for you in as efficient manner as possible, and making sure that you're not going to suffer negative consequences by having the asset titled improperly. Okay. All right. Well, I didn't see any other questions come through the chat box. We're going to check it one more time. If there are questions that come to mind after we end this webinar, my contact information is up there on the screen. Feel free to send me an email at drichardson@eastmantrust.com with any questions that you have. I'm happy to respond to your questions. If you want to schedule a consultation with me or with Dave Eastman, feel free to contact the office. We're happy to meet you, come into the office, sit down with you, review your questions, and we'll do that as a compliment on a complimentary basis for you. Okay, well, with that, we're going to end this webinar, but we do have a drawing that we need to have. And Elisa, what are they winning with this drawing? Okay, so the winner of this raffle is going to be receiving a gift basket, compliments of Eastman Estate Planning. And I have pulled out the name Dan Lowry, I think. Dan L., you are our winner. So congratulations on winning the gift basket. And we will be reaching out to you. Expect a phone call from our office to talk about how to coordinate getting that gift basket over to you. And we hope you enjoy it. And everybody who has attended this webinar, thank you so much for your time. Hope this information was of benefit to you. Again, if you do have any questions or concerns, feel free to shoot me an email, give us a call, and we're here for you. Thank you very much, and you all have a great day.